rationale of protection, then different kind of IPRs, intellectual property rights, then IPRs and licensing, technology agreement. And as you know, the idea, what he said is the intellectual property is here, that is intangible. Nobody can touch it. Okay, it is within your mind only. And when the idea comes from the mind, the idea is intangible. It can become tangible when it is given a product form. Right? And when that product becomes useful, commercially useful, then it has got value. That idea has got value. Right? And how to protect that? So intellectual property is creation, that idea has come, the application of that idea, then you can protect that idea, then only your business becomes successful. Because if your idea is stolen by someone else, then you cannot pursue your business like that particular idea. Okay? Next slide please. So definitely I would like to give one slide to World Intellectual Property Day. The primary objective of celebrating this day is promoting awareness, right? Then encouraging innovation and protecting the creators, fostering global cooperation. Right? Next slide. So there are three kinds of property. Two kinds of property are already known to us, right? Movable properties. We want to possess some car, pet, pencil. Then immovable properties like land, and your buildings, right? Third one is intellectual property. So on which my talk will be revolving this. And this intellectual properties, the name for intellectual property is the my trade, generates from Germany. May take ingredients from outside, but idea comes from it. The nature of intellectual property, what is the parameters by which we can define this as an intellectual property? That is, creation of human mind, that intellect that is coming from here. Then intangible, as I said already, it is not tangible, it cannot be touched. Then exclusive right given to by statute, right? Then attended with limitations and expectations. Time bound, it's not indefinite. If you have a patent, that does not mean the patent has got indefinite, right? Right. And territorial in nature. Next slide, please. Then World Intellectual Property Organization defines intellectual property. So I have taken directly the definition of World Intellectual Property Organization. So intellectual property shall include the rights relating to literary, artistic and scientific works, performances of performing artists, phonograms and broadcast, invention in the field of human endeavors, scientific discoveries, industrial designs, trademarks, service marks, commercial names and designations, protection against unfair competitions, and all other rights resulting from intellectual activity in the industrial, scientific, literary or artistic field. So this is the definition of intellectual property as defined and accepted internationally. Okay, next slide please. So there are various international treaties by which these properties can be protected. Okay, here I have highlighted the treaties like Paris Convention, the Vienna Convention, International Union New Variety, then agreement on trade related aspects. Then the basic principle governing this intellectual property is contract between creator and the sovereign state. For example, suppose you have a new idea, you have a patent, that the state has a responsibility to protect it. Okay, you alone cannot protect it. Right? Then balance between rights of the creator and public interest. Suppose you have come up with an idea which is very useful for human life savings, and you will think you will not license this idea to anyone. Under that conditions, that state will intervene into your right and give necessary royalty to it and disclose that idea for life saving purposes. Right? Next slide. So, what are the various categories of intellectual property? Okay, so like one is patents, and then industrial design, copyright, then trade secret, geographical indications, right? Then layout design, plant variety, trademarks. These are the broad category of intellectual property. Next slide. So scope of the copyright. Right? Then original literary, dramatic, musical, and artistic works. Then here the ideas expressed in the material form. No copyright in idea or fact. Just you will say I have an idea. There is no copyright for that. It has to come in the form of some document, some product. Then rights are of two kinds. One that is moral right and economic right. In case of moral right, the authorship, the right of the individual is being protected. Economic right issues the growth, economic growth. Next slide. Then, this I have already covered, that economic right and moral right. Okay, next slide please. Who is the owners of various rights? Like for literary work. Literary work, the author has the right. Okay. Then drama, in case of drama, the dramatist who are performing. Then music, the composer. Okay. Then artistic work, the artist. Then photograph, the photographer. For example, in the internet, whatever photographs available, okay, all are copyrighted material. We should not use directly without citing them. Okay. So one disclaimer I am using here, basically all the materials I will be presenting here are taken from open source, available in the public domain. Okay. Then author of computer program, the person who has worked on that. Then cinematographic film, the producer. Sound recording, again the producer. Right. In case of in the course of employment, suppose I am an employee of DRDO organization. Okay, if I come up with a novel idea related to my organization, where I have taken salary, I have used the money in conceptualizing that idea, in performing that experiment, in that case the right belongs to the employer. Okay. Then employment by newspaper of the agent and employer has publishing right. Other rights are with author. Okay. Then photograph, painting, cinema, for valuable considerations, persons who take the money. He has the right. Then lecture delivered in public, person delivering. So today's lectures right belong to me. Then government work, it is the government who has the right. Public undertaking, the public undertaking. Then work of international organization who has the sovereign. Work of an apprentice, the teacher has the right. Because under his guidance, he is doing. He is not having his own idea. Right? He is implementing the idea of the person. So essentially the fundamental is the right goes to the person who the idea is germinated from his mind. Right? And who is sponsoring to give a value or useful set to that idea. Then encyclopedia of the dictionary, the editor for that collection. The music under contract by film production, the film producer. Then securing copyright, formality fee protection, voluntary registration, depends on it. For example, many times what we do when someone come up with a good discovery, then if you go for a copyright, it will take time. Okay. Suppose in the meantime somebody else on the other side of the globe, he come up with the same idea and publish a paper of that. Then the matter disclosed. So you will use that your idea, even though idea came to your mind first, just because in the process of copyright takes time always. more time than publishing a paper. Okay. So normally good discovery, papers published in journals or that your nature, journal nature, fundamental kind of works. Okay. So they go for immediate publication so that their idea is benchmark or it is there. Nobody else can claim it is his idea. Right? Then duration, various duration copyrights basically it is like last 15 years. Then similarly all other rights you can reproduce like many times as well. Next topic of next slide. So what is the patents? So this definition I have taken from authentic sources, well established and accepted globally. Okay. So if you see different books, you may find different types of definitions, but these are the correct definitions accepted across the world. The patent is an exclusive right granted from manufacturing or making profit out of that idea or that. In this case, the patents right valid for 20 years. Okay. It cannot be indefinitely. And what can be patented? Everything cannot be patented. Okay. Like it should be novel. The ideas should be novel. Products should be novel. What are the which are not patentable? Okay. Everything as I said, everything cannot be patentable. An invention which is frivolous or which claims anything obviously contrary to well-established natural law. You may say perpetual motion machine. I have developed a perpetual motion machine. Okay, type 1. Do you get patent for that? No. Because it is contrary to the established law of nature. It is not possible. The thermodynamics law restricts, laws of physics restrict construction of a perpetual motion machine 1, perpetual motion machine 2 like that. Laws of gravitation cannot be patented. Okay. Then Newton's laws of motion cannot be patented. The machine whose primary or intended use or commercial exploitations of which would be contrary to public order or morality, that cannot be done. Which causes serious prejudice to human, animal or plant life or health to the environment. Like gambling machine. No matter with how much novel idea you come up with a gambling machine, you cannot get patent for it. Then device for house breaking. Okay. Bulldozers were not made earlier for house breaking, it was made for different purpose. Okay. Then biological warfare material or device. That cannot be patented. Then terminator gene technology, embryonic stem cells. These are few examples which cannot be patented. Then like that next slide, we have covered many things which are not patentable. They are discovery of scientific principles or formulation of an impact, theory, discovery of anything, living substances of in nature. That cannot be done. Right? We have come up with an amoeba first time, the deep sea. So we say they are patent, go for patent for it. Not that. Right? Next slide. That a substance obtained merely by a mixture of resulting from only few aggregation of substances. That is cannot patent. But when the mixture becomes more useful, it will give more additional potential than the individual species, individual component, then for that mixture you can claim for a patent, like soap, detergent, for that you can get a patent. And non-device, if you take non-device and fabricate here and there, for that you cannot get patent. And it makes some novelty maker, like bucket fitted with a torch. You will say in the night I will go to collect water, I will not take torch, my torch is fitted with the bucket. So this entire takes it, I will go for a patent, it will not be patented. Okay. Umbrella with a fan, not patented. Because these are quite obvious things. I will say the novelty is not there, novelty part is missing. Next slide please. Next slide please. Then method of agriculture. for agriculture or horticulture, which are not patentable. Then clones of new varieties of plants, not patentable. Next slide, please. So mathematical methods or a business method or algorithm, computer program passing, that is not patentable.